Hello, I'm Claudia. When British Columbians think about their justice system, they usually picture a courtroom where lawyers argue a case before a judge. But going to court is not the only way that disputes in our society are resolved, and that's where administrative tribunals play an important role. Administrative tribunals are like courts in that they make decisions affecting individuals, generally about how a particular government program will affect an individual person. Disputes about how our laws are applied are bound to arise, whether it is between individual citizens and government or citizens and groups, such as private business or companies. The law developed from the resolution of these disputes is called administrative law. In British Columbia, administrative tribunals make tens of thousands of decisions every year that affect individual citizens and the broader community. Because we might not even be aware of how administrative law touches on our lives, it can seem that it is invisible law. Think about your day. What did you have for breakfast? If you had eggs, the quality of the milk and the color of the butter were regulated, which means that rules are made and enforced by the Canadian Dairy Commission. Your telephone or cell phone? The rates you pay for using these phones were regulated by the Canadian Radio and Television Commission. The BC Utilities Commission regulates the rates we pay for the electricity we use. And when you go to work, the number of hours you work and payment for overtime are administered by the Employment Standards Branch, which decides whether you are owed overtime. If you disagree with their decision, you can appeal to the Employment Standards Tribunal. The Employment Standards Tribunal was created by legislation, which is a type of law made by government. All administrative tribunals are created by legislation, at the federal level by the government in Ottawa, at the provincial level by the government in Victoria, and at the local level by city councils through bylaws. As well, many professional groups such as lawyers, dentists, teachers, veterinarians, and chiropractors, known as self-regulated professions, are given authority through legislation to create their own tribunals to deal with complaints from members of the public, resolve disputes, and decide on qualifications for their members. Although administrative tribunals come in all shapes and sizes, what they have in common is that they provide a quicker, less costly, and more accessible alternative to the courts. For example, when a person takes their case to the Employment Standards Tribunal, they have the right to be represented by a lawyer. However, it isn't really necessary to have one. It's more likely that you will need a lawyer if you go to court than if you go to an administrative tribunal. Administrative tribunals are more informal than courts and are more flexible about ways of hearing a case, recognizing that people who come before an administrative tribunal generally are not represented by a lawyer. The decision makers in these cases have specialized knowledge in their field. For example, the Employment Standards Tribunal have expertise in employment standards. Decision makers for administrative tribunals are typically referred to as members, adjudicators, or judges. We will refer to them here as adjudicators. They only hear cases in the specific area that the tribunal is required to consider, and so over time, they develop specialized knowledge and expertise in that area. Adjudicators resolve disputes in many different ways. They can issue a written decision, mediate a dispute, and, depending on the tribunal, they can also investigate, regulate, and make policies. The Employment Standards Tribunal usually resolves disputes by writing a written decision, but if the parties are interested in mutually agreeing on a settlement, the tribunal will assist them in doing so. Although administrative law affects many aspects of our daily lives, the interests at stake for an individual can be very serious. Will this person be granted parole from prison? Will that person be granted immigration status to remain and work in Canada? Will this company be able to build a high-rise condo complex on this property? Will that doctor lose his privileges to work in a hospital? Or will that pilot lose her license? These are decisions that can deeply impact the lives of private citizens. It is important to have fair and just processes. In administrative law, this is known as the duty to be fair, and it involves 4 principles. The first principle states that A person affected by an administrative decision has the right to know the case against him or her, and must be given an opportunity to respond. How this principle is applied depends on the circumstances. For a dispute over overtime pay before the Employment Standards Tribunal, this principle means that the employer has to back up their position by giving the employee and the adjudicator a written submission. That is, his arguments, together with evidence and affidavits, or the sworn written testimony of witnesses. The employee has an opportunity to respond in writing to all of the points he has raised and to provide their own evidence and affidavits. In another dispute, however, fairness might mean that the parties, the people or organization or company or government agency in the dispute, must go to the tribunal in person to present their case in a formal meeting. This is known as an oral hearing. The second principle is that a person is entitled to a decision from an unbiased adjudicator. An unbiased adjudicator is someone who makes a decision based on the evidence and arguments that are presented, and nothing else. The adjudicator must act independently without influence from any outside source. It also means that it can't even look like the adjudicator might be biased. For example, the adjudicator cannot be someone who has a family connection or a personal relationship with any of the parties. The adjudicator also cannot be tied to the parties in any way that suggests that it might be financially to his or her benefit to make a decision in favor of one party rather than another. In other words, justice must be done and it must be seen to be done. The third principle is that the person who hears the case must decide the case. This principle means that a case cannot be decided by someone who did not read the submissions. For an oral hearing, this principle means that the case cannot be decided by someone who was not in the room to hear it. This principle also means that if there are government policies that relate to the case, these policies should only be applied if it makes sense to do so in the particular facts of the case. For example, in the workers' compensation system, if the Workers' Compensation Board has a policy about how to determine the average earnings of a person making a claim, in an application for benefits, the board must consider whether it actually makes sense to apply the policy in the circumstances of the case, and not just blindly follow the policy without considering whether it is appropriate in the circumstances. And finally, the decision maker must give reasons for a decision. In some cases, there is a significant amount of money involved, and it is important that all parties know the reasons for the final judgment. The details this principle requires will depend on the nature of the case and the circumstances. One size does not fit all. For example, in a case where the Immigration and Refugee Board makes a determination of refugee status or denies entry to Canada of a spouse or an adopted child, the reasons must be comprehensive. Because one size does not fit all, if you want to find information on how the duty to be fair is applied to specific tribunals, be sure to use the search feature on this site. And if you are appearing before any particular tribunal, make sure you are aware of that tribunal's rules.